Hello everyone, my name is Vaishnavi Parate. I am a human rights activist at All India Human Rights Association, and today we are going to discuss and learn about what is Bharatiya Nagarik Suraksha Sanhita Bill 2023. So let's start. Let's start with the introduction. The Bharatiya Nagarik Suraksha Sanhita 2023 was introduced in Lok Sabha on August 11, 2023. It repeals the Code of Criminal Procedure 1973. The code provides for the procedure for arrest, prosecution, and bail for offences under various acts, including the Indian Penal Code 1860. The bill retains most of the provisions of the code. The Bharatiya Nagarik Suraksha Sanhita bill will have 533 sections, including 160 sections of old law that have been changed, 9 new sections have been added, and 9 sections have been repealed. Now let's see what are those major changes made in the bill. Detention of under trials. Under the code, if an accused has spent under detention half of the maximum period of imprisonment for an offense during investigation or trial, he must be released on his bond. This does not apply to offences which are punishable by death. The bill adds that this provision will also not apply to offences punishable by life imprisonment and persons against whom proceedings are pending in more than one offence. It further adds that first-time offenders will be released on bail if they have completed detention for one-third of the maximum imprisonment that can be imposed for the offence. The superintendent of the jail where the accused is detained must make the application seeking the release of such under trials on bail. Trials in electronic mode. The bill provides that all trials, inquiries, and proceedings may be held in electronic mode. It also provides for the production of electronic communication devices likely to contain digital evidence for investigation, inquiry, or trial. Electronic communication includes communication through devices such as mobiles, computers, or telephones. Medical examination of the accused. The code allows conducting a medical examination of the accused in certain cases, including cases of rape. Such examination is carried out by a registered medical practitioner at the request of at least a sub-inspector level police officer. The bill provides that any police officer can request for such an examination. Metropolitan magistrates. The code empowers the state government to notify any city or town with a population of more than 1 million as a metropolitan area. Such areas have metropolitan magistrates. The bill omits this provision. Forensic investigation. The bill mandates forensic investigation for offences punishable with at least 7 years of imprisonment. In such cases, forensic experts will visit crime scenes to collect forensic evidence and record the process on a mobile phone or any other electronic device. If a state does not have a forensic facility, it shall utilize such facility in another state. Power to prohibit carrying arms. The code empowers the district magistrate to prohibit the carrying of arms in any procession, mass drills, or mass trainings with arms in public places. This may be done to preserve the public peace and public safety or maintain public order. Such prohibitions may be in place for up to 6 months. However, the provision was not notified under the code. The bill omits the provision. Signatures and finger impressions. The code empowers a metropolitan or judicial magistrate to order any person to provide specimen signatures or handwriting. Such an order can be given for any investigation or proceeding under the code. However, such a specimen cannot be collected from a person who has not been arrested under the investigation. The bill expands this to include finger impressions and voice samples. These samples may also be taken from a person who has not been arrested. Timelines for procedures. The bill prescribes timelines for various procedures. For instance, it requires medical practitioners who examine rape victims to submit their reports to the investigating officer within 7 days. Other specified timelines include giving judgment within 30 days of completion of arguments, extendable up to 60 days, informing the victim of the progress of the investigation within 90 days, and framing of charges by a sessions court within 60 days from the first hearing on such charges. Trial in the absence of the offender. The bill provides for the conduct of trial and pronouncement of judgment in the absence of a proclaimed offender. This shall be done when such a person has absconded to evade trial and there is no immediate prospect of arresting him. Proclaimed offender refers to a person who is accused of an offense punishable with imprisonment of at least 10 years or death and fails to appear at a specified time and place as specified by a court.